Well, good afternoon and thank you for joining us today. My name is Claire Sherratt and I'm the Professional and Operations Lead with particular oversight for the enforcement area. The Operations Lead role is a role I've been seconded to for my normal inspector role for the past 3 years. I'm joined today by two of our very experienced enforcement inspectors, Jeanie Russell and John Murray. We've all been involved in delivering enforcement training to inspectors over the years, and Jeanie is also the co-chair of the Planning Inspectorate's Rainbow Network. The webinar is divided into three parts. Firstly, I'll say a little bit about the appeal service in general and what to expect once an appeal is validated. And then secondly, Jeanie is going to look at what an enforcement notice should contain and the various grounds of appeal. John will then look at some of the more tricky areas of enforcement, including planning units, mixed uses, primary and incidental uses. Now you can ask questions in the Q&A. So if you see a question that's been posted that you're particularly interested in hearing the answer to, you can upvote that question. And now to do that, you click on the up facing arrow. So it's not by liking it. You'll see there's a little up facing, north facing, or however we want to refer to it, arrow. And then we can see which of the questions that you're asking you would most like us to answer. And we will try to make sure we get to as many of those as possible within the time that we've got. And I'd also just like to remind you that we cannot comment on any live casework. Okay, so if we turn then on to part one, I'm going to start with just a couple of slides, I promise, just a couple relating to the appeal service before we move on to the key topic areas. So essentially, we aim to issue appeal decisions where the hearing or inquiry procedure is followed in 24 to 26 weeks. And for those progressing by written representations within 20 weeks. They are our ministerial measures and apply to both planning and enforcement appeals. And as you'll probably be aware, the Planning Inspectorate has been focusing on specific areas to improve performance, one area at a time. And we started with planning appeals, initially inquiries, then hearings, and still an area of focus for us at present is our written representation planning appeals. And the age profile of those has reduced quite significantly of late. So a few years ago, that focus shifted to include our enforcement appeals, and we have made huge improvements to the time it takes to progress the enforcement appeals, proceeding by hearings and inquiries. So I hope that you've now benefited from those improved timescales. There are, though, a small number of very old hearing and inquiry cases in the system that are impacting on the mean and medium times published on the gov.uk website. So they are not really representative of what you can expect for the most part when we receive an appeal now. For inquiries, an inspector will be appointed at the outset and the event date is fixed for 17 to 20 weeks ahead. Now, the inspector will ask you to attend a case management conference around week 8 to discuss procedural matters and in particular how they intend to run the inquiry and how long will be needed. So please do come prepared to assist the inspector with timings and other procedural matters. You will be advised beforehand what the inspector wishes to discuss. In hearing cases, again, an inspector will be appointed at the outset and the event date is fixed somewhere between 13 to 16 weeks ahead. Now, we may hold a case management conference for hearings if the inspector feels that would be helpful. So we still have a large backlog of enforcement written representation cases, unfortunately. So when I say enforcement, I mean both our Section 174 appeals and the lawful development certificate appeals. Now, this is the last big appeals area of focus. So today we do still have around 3,500 open written representation appeals. Now, that includes linked child cases, and those already with inspectors. So just over 2,400 of those are what we call lead or non-linked appeals, where an inspector has not yet been appointed or a site visit arranged. So that's our pot, if you like, that still need to be allocated to an inspector. Now, the reality is that we do have some very old appeals in that written representations pool. Some 35% are still over 52 weeks old, and we are primarily focusing on the oldest cases first. So not all our inspectors are available to conduct enforcement appeal casework. That group is actually relatively small. And generally, we will give our inspectors site visits for up to a period of 10 to 12 weeks ahead at any given time. So I want to assure you that we're not being complacent about the need to address this pool of cases. We know that the timescales need to improve. Our aim is to have determined and closed enough of the older cases that only a small percentage, if any, of those open cases that are left are over 52 weeks by the end of March next year. Now, we receive an average of about 55 new written representation appeals a week, so it goes without saying that we need to close more than that, so more than we receive to be able to tackle that backlog. So please do perhaps bear this in mind before chasing our casework teams for updates on any cases you have with us. They are very busy and will probably actually not be able to update you beyond what I've said today. We are, of course, considering different ways in which we can work more effectively to get through the written representations backlog as quickly as possible. One is that we will no longer be linking planning and enforcement appeals for the time being, which should help us concentrate on those older appeals. And we are also starting to pull out some data that might allow us to explore ways we could approach the allocation of cases to inspectors differently, depending on the grounds that are made in any appeal case. Okay, so turning to appeal tips. There are a few appeal tips set out on this slide, which I think are probably self-explanatory, so I'm not going to go through them all. But if I can highlight just a couple, if I may. Now, an appeal, as we know, has to be made before the effective date of the enforcement notice. So if there is scope to potentially resolve matters through an alternative scheme or with conditions, could I make a plea to local authorities to please consider giving enough time before setting the effective date to allow that to happen? We will not normally delay determining an appeal anymore because there is an outstanding retrospective application or perhaps a Section 106, for instance, that's outstanding. So once the appeal is made, we will proceed to determine it in accordance with the timetable. And as you know, hearings and inquiries, that process moves quite quickly now, and it involves work at each stage to meet that timetable. So possibly this could be avoided by making sure the effective date gives some time for alternatives to be explored. I'd also ask that local authorities check that the notification of an appeal includes all the information required so that doesn't avoid delays if it needs to be done again. And there is actually a model notification letter that can be followed to help with that. Now, there is a lot of wasted time and expense for everyone if a party does not turn up to an arranged accompanied site visit. The inspector will consider in those circumstances if they do need to actually view the appeal site from private land. They may be able to proceed without doing so, but they may well need to rearrange and all that time and expense is repeated. So an inspector might decide to rely on the written information only if there are particular difficulties with a party not attending. And in some instances, if the inspector does need to access the site and has not been able to due to the appellant or the representative not attending, the inspector may issue a warning notice under Section 176 and could potentially dismiss the appeal in those circumstances. So if I can just end by quickly reiterating just how helpful inspectors find concise statements of case, proofs of evidence, using core documents is really helpful, and receiving statements of common ground. The more you're able to narrow the matters in dispute through ongoing discussions before, the more focused the event can be. So thank you very much. And on that note, I will hand over to Jeanie.
Thanks, Claire. So yes, and as Claire said earlier, I'm going to talk through the contents of an enforcement notice and what all of the grounds of appeal are about. So firstly, issuing an enforcement notice. So under section 1721 of the Town and Country Planning Act, a local planning authority may issue an enforcement notice where it appears to them that there has been a breach of planning control and it is expedient to issue the notice, having regard to the provisions of the development plan and any other material considerations. The word appear is very important. The local planning authority does not need to be certain either that there has been a breach of planning control or that planning permission would never ever be granted for the development that's taken place. Expediency is entirely a matter for the LPA. However, once they do decide to issue a notice, its contents must comply with both section 173 of the Act and regulations 4 and 5 of what we call the enforcement regulations. I would also encourage authorities and people who receive a notice to have regard to advice that's set out in the Planning Practice Guidance chapter on enforcement and post-permission matters. I'm going to focus on the 4 most important parts of a notice now from an appeal perspective, but there will be a bonus slide, if you like, with information on other contents that are required. So firstly, the boundaries of the land. A notice must specify the precise boundaries of the land to which the notice relates, whether by reference to a plan or otherwise. And the words or otherwise, which are in regulation 4C, what they mean is that attaching a plan is not essential. The starting point is to describe the address of the land correctly within the body of the notice, as this sort of screenshot from the model notice shows. That said, attaching a plan that shows the boundaries of the land is helpful, especially if the land associated with the particular address is not obvious. It's not essential that the site exactly matches the planning unit, a concept which, as we know, John is going to talk about later. But in material change of use cases, if at all possible, the site should encompass the whole area that is occupied for one or more main purposes or primary uses. Thanks. The second key part of the notice is the allegation, or the matters which appear to the LPA to constitute the breach of planning control. That term, a breach of planning control, is defined in section 171A as having 2 limbs, and it's useful to have regard to how these 2 limbs are defined when looking at how to frame an allegation in the notice. And also, so the first limb is carrying out development without the required planning permission. The definition of development given in section 55 of the Act is a good starting point for then framing the allegation. So one type of development, the making of a material change of use of land. So a notice might allege the making of a material change of use of land from use X to use Y, or in mixed use cases, say from use X to uses X plus Y. The definition of development can also be helpful, say, for framing the carrying out of engineering operations, perhaps to form an access road. However, building operations can be described more succinctly in an allegation, and simply saying the construction of a building or an extension would usually suffice. But regard should be had as to what development is if you are going to allege that there has been development without planning permission. The second limb of a breach, the second type, I should say, of a breach of planning control is failing to comply with any condition or limitation subject to which planning permission has been granted. And that includes not only conditions that are imposed on any grant of any planning permission that's granted expressly by the LPA on application or granted by an inspector on appeal. It also applies to conditions and limitations that are imposed on permitted development or PD. In these cases, the allegation will look different to the way it does if the allegation is development without planning permission. As I say, in those cases, It can be quite a simple allegation, the making of a material change of use, and so on, perhaps even just one sentence. But in failure to comply with condition cases, the allegation should contain much more information. Give details of the original planning permission, including the description of development that was approved. And I'm going to use an example here. Planning permission was granted on such a date, such a reference to a material change of use of the ground floor to a takeaway. Then give the text of the relevant conditions or limitations that the local authority thinks has been breached. And that could be a condition requiring that the takeaway only stayed open to customers until midnight. Then, if appropriate, give the reasons for the condition, which was in this case to protect the living conditions of nearby occupiers. And then finally, how the condition or limitation has not been complied with. So again, in this hypothetical case, the condition number 2 imposed on the planning permission for a takeaway has been breached because the takeaway is now staying open until 2 a.m. Significantly more information is required there, and the format looks a bit different than in the first type of breach. As I say, the matters which appear to constitute the breach of planning control will be described differently depending on whether the notice is concerned with development without permission or breach of condition. Now, a single notice may allege that more than one development has taken place without planning permission. So, for example, the making of a material change of use of a dwelling house to, say, 6 flats, plus the construction of an extension to the building. A single notice can also allege that there's been a failure to comply with more than one condition on the planning permission. Sometimes it isn't clear whether the breach falls within A or B. A material change of use may be development without permission, and it may also be in breach of condition at the same time, because conditions can control the uses. Development that's not carried out in accordance with approved plans may deviate so significantly from the approved plans that it's considered development without permission at all, but it can also be said to be in breach of a plan's condition. In these sorts of scenarios, for the local authority, 2 notices can be issued in the alternative, and then perhaps if both are appealed, the inspector would quash one. However, a single notice cannot be used to tackle both kinds of breach. We would not expect to see a single notice that alleges that development is simultaneously without planning permission and in breach of a condition. I call it a Schrodinger's breach because it's both with and without permission at the same time. The real problem with these notices is that they would give rise to 2 different deemed planning applications, and it just gets too messy. So although one notice can include more than one breach, it should only be the same type of breach on one notice. Thank you. So then the third crucial part of a notice is the requirements. A notice shall specify the steps which the LPA require to be taken or the activities which the LPA require to cease. The requirements apply in posterity. Compliance with the notice does not discharge the notice under section 1811. In terms of mistakes we sometimes see, the requirements must match the allegations, so do word them consistently. If the allegation is a material change of use, require the use to cease. If that's the outcome that is wanted, tie it to the allegation. If the allegation is a material change of use to parking, then don't require the cessation, or require the cessation of parking rather than cessation of a different use. If the allegation is construction of a side extension, require removal of the side extension. And if the allegation is a breach of condition, require that the condition is complied with. So again, using the previous takeaway example, if there is a breach of an opening hours condition, require that the condition is complied with. I know that sounds very obvious, but we do see, for example, say an allegation of a change of use to parking of vehicles and a requirement to cease the storage of vehicles, or just generally perhaps different words being used that can give rise to different nuances of interpretation. So just do be consistent and check notices for consistency. Under section 1734, the requirements of a notice can have different purposes: to remedy the breach of planning control, to remedy the injury to amenity that was caused by the breach. And with injury to amenity, we basically mean by that the planning harm. The purpose of the notice is not the same thing as the reasons for issuing the notice. The reasons set out why the notice was issued, the planning harm that the LPA is concerned about, but the purpose relates to the outcome that the LPA wants to achieve, and it should be clear from the requirements. So, for example, if a notice alleges the construction of an extension without planning permission, then a requirement to remove the extension, the purpose there is to remedy the breach. The outcome that the council wants is to go back to before the breach occurred, remove the extension. If the notice simply requires that a window in the extension is bricked up because the extension causes harm by overlooking, then there the purpose of the notice is to remedy the injury to amenity. But it is by interpreting the requirements in that way that you can understand the purpose of the notice. Requirements can be very significant and include, for example, constructing a replacement building, as happened famously in the case of the Carlton Tavern. Remedying the breach of planning control can mean putting the land back to its previous condition. However, a notice cannot do more than that. It cannot take away lawful use rights. It cannot require that the land is improved compared to its previous condition, and it cannot require that a lawful use is actually resumed. A word about section 173(11) of the Act, which everyone should be aware of. And it arises in cases of under enforcement. So perhaps in that case of the requirement, the example here of the requirement to brick up the window. If a notice could have required that works are removed or a use is ceased, and a notice could require that where those things are alleged, but the notice does not require removal or cessation, it has lesser requirements, and those lesser requirements are complied with, then planning permission is treated as granted for the works of activity. So to give a different example, if a notice alleges a material change of use to parking, it doesn't require that the use is ceased, but it only requires that the cars are removed. Then once those cars have been removed, once that requirement has been complied with, the parking use can resume because the notice doesn't prevent that. So section 173(11) is something to be very mindful of. Thank you. And the final key part of the notice that I'm going to talk about is the time for compliance. A notice must set out one or more periods of time for compliance with the requirements. Each requirement can have its own period, or there can be a single period of compliance with the requirements collectively. Either way, the recipient should have reasonable time to do everything required of them, considering, for example, whether any works required by the notice could take place before the use is ceased. So using the example again of a change of use of a dwelling house to flats, there should be reasonable time to cease the use, allowing the occupiers of the flats to look for new homes and actually move out. And it's only after they've gone that the landowner can start ripping out the kitchens and putting the building back to its previous condition. So it needs to bear in mind the sequence and the timing of all the requirements. In any case, the time must be expressed as a period. If you require, for example, that the use is ceased immediately, that is not a period of time. Calendar months are usually fine. Thank you. I'm not going to run through this slide. It is self-explanatory, but these are other things that an enforcement notice must contain. Thank you. So my final slide on notices is I'm going to talk about corrections and variations and the concepts of null and invalid notices. Firstly, just to refer to section 173A of the Act, that allows an LPA to withdraw a notice after it's been issued, or to waive or relax any requirement, or to extend the period of compliance. Those powers are not for the inspector, and other than occasionally referring to them, it's not for us to comment on whether or when an LPA might exercise those powers. They are not for us. However, if a notice is appealed, the inspector does have powers under section 1761 of the Act to A, correct any, excuse me, I need some water. To A, correct any defect, error or misdescription in the notice, and that means any part of the notice. Or B, to vary the terms of the notice, with the terms being the requirements and or period time for compliance. The only limitation on the power to make corrections or variations is that doing so must not cause injustice to the appellant or the LPA, and there is no rule about what would or would not cause injustice. Widening the scope of the notice so that it relates to a larger site or more uses of land, that will often cause injustice. It would make the notice more onerous for the appellant to comply with. However, it does always depend on the circumstances and evidence. If correcting any error, defect or misdescription, or varying the terms for that matter, would cause injustice, then the notice is invalid. Simple as. But it is usually necessary to read the evidence to identify the error and whether correction would cause injustice. So, for example, if the allegation and requirements don't match, if you have an allegation of car parking and the requirements relate to car storage, you wouldn't know from the notice itself whether the allegation is correct or whether the requirements are correct, and you also wouldn't know the implications of making the correction. So invalidity, it relates to the concept of injustice, and we often need evidence to judge that. But a notice is null if it is so defective on its face that it does not amount to an enforcement notice in law at all. And if that's the case, the question as to whether corrections would cause injustice cannot even arise. And that might be the case if the notice is hopelessly ambiguous and uncertain, or if its contents do not include everything that I have talked about so far, what is required under section 173. Thank you. So now turning to the grounds of appeal, and these can be grouped, if you like. So what are commonly referred to as the legal grounds, this is the sequence in which we don't take the grounds of appeal in alphabetical order, we take them in this sequence. Grouping first of all the legal grounds, which are grounds E, B, C and D. And in these cases, well, the inspector is making a finding in law on all of these grounds. The onus is on the appellant to make their case, and the standard is to the balance of probability. So it has to be, we're looking at what is probably the case. Then ground A, which gives rise to a deemed planning application, that concerns the planning merits of development and whether planning permission should be granted for what is alleged. And then the final two grounds, which I think are grouped together as a sort of, these are about mitigating the impacts of the notice on the recipients, and their grounds F and G, all set out under section 1742 of the Act. So starting with ground E, and this is that copies of the notice were not served as required by section 172 of the Act. We talked about section 1721 earlier. That defines, that's the power to issue a notice where it's expedient. Service is covered under sections 1722 and 1723. Section 1722 requires that a copy of the notice should be served on the owner or owners and occupier or occupiers of the land to which the notice relates, and on any other person having an interest in the land, which in the opinion of the LPA is a materially affected interest. In practice, the notice should be served on any owner or occupier of the property except a trespasser. And the owner or occupier doesn't necessarily need a paper contract in order to not be a trespasser. So the vast majority of people with an interest in the land there would be served. And and then section 1723 requires that the notice is issued not less than 28 days after issue, or 28 and not less than 28 days before the date to take effect. A recipient must have at least 28 days to make an appeal. As Claire said earlier, they can be given a bit longer, but they certainly cannot be given less. There are also requirements in service set out, just for information really. Section 329 of the Act and the Town and Country Planning General Regulations contain a few more requirements for service that we would have regard to, but Ground E is concerned with section 172, and so it's about who receives it and the time when they receive it. We always take Ground E first, because if the notice was not properly served, it should be quashed, because people who weren't properly served have not been given a proper right of appeal. However, that is not the outcome. The notice would not be quashed where section 1765 of the Act applies. If it would be otherwise a ground for allowing an appeal that a person was not served, that finding or that fact may be disregarded if neither the appellant nor that person has been substantially prejudiced. So in effect, if you should have been served but you weren't, or you just received the notice after 26 days, but you have made an appeal and you have put forward your case, then you were probably not substantially prejudiced by the failure to serve you properly, and Ground E would not succeed. So Ground E appeals quite often do not succeed because of the substantial prejudice provision of the Act, but nonetheless they do sometimes, and it is obvious, of course, it is very serious. It is the first ground of appeal for a reason, because it's very serious if the notice is not served as required. So the next ground that we would take is Ground B, and this is that the matters, and what we mean by the matters is the alleged breach of planning control. And Ground B is where the recipient believes that they just have not occurred. And this is a question of fact or fact and degree. Ground B is strictly concerned with the accuracy of the allegation and whether it had occurred, note the past tense, by the date of the notice. So to take as an example, if we have an alleged material change of use to a residential caravan site, if caravans are in fact stationed on the land for human habitation, Ground B will fail. The matter has occurred as a matter of fact. If caravans were on the land in the past for human habitation, but that use has ceased, the use ceased before the notice was issued, well, Ground B will still fail. The notice will be upheld so that it takes effect in posterity and the use cannot resume. But if the use was in fact storage of caravans, well, then Ground B will succeed. And if the caravans were never ever there, then again Ground B will succeed. If there is success on Ground B, the outcome will be that the notice is quashed unless the notice was concerned with more than one type of development and there is only partial success on B, and then in that case the notice will be corrected so that the part that did not occur is deleted from the notice, but the notice remains for the part that had occurred. And that's a same approach, that a notice would be quashed or corrected, that also applies to Grounds C and D. A common scenario that we see with Ground B appeals is when, say, for example, we've got the same alleged material change of use to a residential caravan site, and what if the appellant thinks that is wrong because the change of use was not material? This can sometimes be considered under B, but for me, it takes us squarely to Ground C. So Ground C is that the matters, if they occurred, do not constitute a breach of planning control. Ground C is written in the present tense, and it concerns whether, on the date of the notice, whether what is alleged, and that might be as corrected, is development, firstly, is it development as defined by section 55? Does it require planning permission? Perhaps is there a lawful development certificate there already? If planning permission is required, then the next question is, has it been granted? Perhaps because by the GPDO, or perhaps by a planning application or appeal. And if planning permission has been granted, then we also need to look at whether that is still extant. So going back to the previous example, with the material change of use to a residential caravan site, for me, I would an argument that there are no caravans on the land, or it's not residential use, that would fall within ground B. But if there is a question as to whether the change of use required planning permission, or perhaps the caravan was there for incidental purposes instead, those for me are ground C arguments, because they concern whether or not there has been a breach. It may be necessary, and often is in ground C cases, to interpret a previously granted planning permission to decide whether it encompassed what is alleged, and that can particularly be the case where something has been built which does not accord with approved plans. The approach to interpretation should be straightforward, pragmatic and purposive. Look at the ordinary meaning of the words on the planning permission in their statutory context and in the context of other circumstances. If there is a question as to whether a planning permission was implemented on time, section 56 of the Act sets out tests for when development was begun. The approach we recommend taking is that identify both similarities and differences between what was approved and what has been built, and then make an overall assessment of the significance of the similarities and differences. In failure to comply with condition cases, ground C may concern whether the condition was in fact complied with, given its wording, but also the validity of the condition and whether it met the legal tests for conditions. Again, then there can be questions of interpretation. But the same approach of reading the words in a straightforward way and looking at the purpose behind them is what we would the approach we would take. So now we're at ground D, which is that on the date that the notice was issued, no enforcement action could be taken in respect of the matters. Ground D concerns whether it was too late to take enforcement action, again on the date of the notice, such that the development is what we would refer to in shorthand as is whether the development is immune from enforcement. The time limits are set out under section 171B, and they were amended last year. So, and I think we will be seeing this coming through. With operational development, buildings, engineering works and so on, beginning with the date that the operations were substantially completed, no enforcement action can be taken after 4 years if substantial completion was before 25th of April last year, or 10 years if the date of substantial completion was on or after 25th April last year. The same applies with a change of use to a building as a single dwelling house, or a failure to comply with a condition that prevents the use as a dwelling house. In this case, it's beginning with the date of the breach. The immunity period is 4 years if the breach occurred before 25th of April last year, 10 years if the breach occurred after that date. Any other breach of planning control, which essentially means any other material change of use, any other failure to comply with a conditional limitation, the period for immunity has been and remains 10 years, beginning with the date of the breach. In all change of use and condition cases, the breach should not only have first taken place 4 or 10 years ago, but it should have taken place throughout the period without significant interruption. So, and I'm just going to now explain on the next slide, please, some of the terms that I've used there for some of the key terms for ground D. So when we talk about the period of 4 or 10 years beginning with the date of the breach, The clock does not run back from the notice. The clock runs forward from the breach of planning control. So development may be immune from enforcement action if it's got the 4 or 10-year period, even if it's not actually taking place on the date of the notice. When we talk about substantial completion in respect of operational development, what that means in the context of building operations is that there should be a fully detailed building of a certain character. A building may not be substantially completed, even if the only outstanding works on their own would not require planning permission. So immunity clock does not even start to run down until it's substantially completed. When we talk about the date of a material change of use, we look at 2 factors in that case, generally the physical state of the building and actual intended or attempted use. Neither is necessarily decisive, and when we talk about actual intended or attempted use, it doesn't mean the use must actually have been begun. So going back to one of my previous examples, a material change of use of a dwelling house to flats, to decide when that material change of use occurred, we would be looking at when were the additional kitchens, bathrooms, subdivisions put into the building, and when was it first let? When was it first advertised for letting? What was the intention behind carrying out those works? And we would assess those matters in the round. When we talk about that a use must take place without significant interruption, again, this is a judgment call. This is a fact and degree, but in material change of use and failure to comply with condition cases, the breach must have probably continued excuse me, throughout the whole 4 or 10-year period, such that the council, the LPA, could have taken enforcement action at any time. So again, perhaps looking at the flats, the LPA might knock on the door after 3 years or 9 years, and they might see an empty flat, but is it being advertised? So it's has it been empty? How long has it been empty, and why has it been empty? Could the council realistically have taken enforcement action against the use of a building as a flat at that time? The use of that part of the building as a flat even. So a final point on ground D is development that is immune from enforcement action is lawful, although where the allegation is non-compliance with a condition and that has become immune, it is only lawful to continue the same non-compliance. The condition is not actually discharged, and if it is complied with again, another breach would need another 10 years. So going back to the hot food takeaway before, if there were the condition required that the takeaway closes at midnight every night, the proprietor opens till 2 a.m. on Fridays and Saturdays. They've done that continuously for 10 years. They succeed on ground D, but all they can do is continue opening till 2 a.m. If they sell the takeaway on and the next proprietor goes back to closing at midnight, but then changes their mind and goes again to opening at 2 a.m, well, that's after the period of compliance with the condition, the new breach will need another period of compliance. The condition has not actually gone. So ground A, and I haven't put in the full text of that here, but it is that planning permission should be granted essentially for the matters alleged. Pleading ground A gives rise via section 1771 to a deemed planning application for which a fee is normally payable. The planning merits of the development alleged cannot be considered if ground A is not ticked and the fee is not paid. Once those things are done, however, the powers available to the inspector are to grant planning permission in respect of the whole or any part of the matters, or the whole or any part of the land, and they can also discharge any condition or limitation subject to which a planning permission was granted. The description of development is taken from the allegation, whether as it stood or as it was corrected, but the inspector cannot consider an alternative scheme that is not part of the matters, and also an inspector cannot correct the notice essentially for the purpose of defeating the object of the notice and granting planning permission for something that the council was not enforcing against. It is also another point to be aware of is it is not possible to tie any planning permission granted via Ground A to any plans. If the evidence shows that the development could be modified within its description to make it acceptable, the inspector may grant planning permission subject to a condition which requires that details of the amendment are submitted later to the council for approval and are then implemented within specified timeframes. In order that the LPA could then enforce against any non-compliance with that condition, in other words, if the scheme is not submitted or it's not implemented in accordance with the approved details, if that to prevent that sort of scenario, the condition should include a sanction which is perhaps akin to the requirements of the notice, i.e. perhaps to remove the building or cease the use if the stipulations are not met. So we can grant planning permission for what is alleged, but if amendments are necessary to make it acceptable and fall within the description, well, yes, we'll grant planning permission, but the council's powers of enforcement will be backed up because the condition will say if you don't follow these extra steps, the building should be removed. The deemed planning application is considered like any other retrospective planning application in the sense of with regard to the provisions of the development plan and any other material considerations. The human rights of the appellant and or interested parties and or the public sector equality duty are not engaged in the legal grounds, but they may be in Ground A because the inspector is exercising discretion here as to whether or not to approve or refuse planning permission. Success on Ground A will mean that the notice is quashed unless there is a split decision. If planning permission is granted only for part of the matters or part of the land, the notice then will be upheld, but it will cease to have effect insofar as it is inconsistent with the planning permission. Section 181 gives that protection to the parties concerned. Another change to the Act last year is that there are new limitations on when we can and cannot accept a Ground A. This applies to any enforcement notice issued in England on or after 25th of April this year. We need to look at whether there has been a related planning application. If there wasn't, that's fine. We would accept a Ground A appeal and ask you for the fee. If there has been a related planning application, then we need to ask another question, was when did that related application, including any appeal that followed it, cease to be under consideration? If the final decision, whether on application or appeal, was 2 years or more before the notice was issued, then again we can accept Ground A. But if the application ceased to be under consideration less than 2 years before the notice was issued, then we will be declining Ground A. And a related application for these purposes is one where if planning permission was granted for the development applied for, planning permission would have been granted for what is specified in the notice as constituting a breach of planning control. So we will have to look at, again, differences and similarities between what was proposed in the planning application and what is subject to the appeal. But assuming that they are essentially for the same thing and the application ceased to be under consideration less than 2 years ago, we will have to decline Ground A appeals. Thank you. So my penultimate slide, with relief, is we're looking at Ground F, and that is that the requirements of the notice exceed what is necessary to remedy the breach of planning control or the injury to amenity. So a starting point, it goes back to what I talked about earlier. The starting point for Ground F is we have to ascertain the purpose of the notice, and that is what the LPA wants to achieve. Ground F is not about overcoming objections, which I'm afraid our appeal form does still say. Apologies for that. That is not what Ground F is about. And it is not actually about the development at all. Ground F only concerns the requirements of the notice. So to identify the purpose, as I say, we understand the purpose of the notice from looking at the requirements. If the requirements are along the lines of cease the use, remove the building, restore the site, comply with the condition, then the purpose is to remedy the breach. And all that can be pleaded on ground F, you can only plead ground F, is if those requirements exceed what is necessary to remedy the breach. Requirements are likely to be excessive if they remove lawful use rights, or require improvements to the land, or require resumption of the lawful use. So say, for example, you change of use of a dwelling house to flats, to remedy the breach, cease the use as flats, put the building back into its previous condition. It would be excessive to say resume use of the building as a single dwelling house. That would be excessive to remedy the breach. However, those basic requirements that have said cease the use, remove the building, restore the site, comply with the condition, they are rarely excessive. That is usually, those sorts of requirements are in fact usually necessary to remedy the breach, which is the outcome the notice seeks to achieve. Where development did not accord with approved plans, a notice can give a choice of requirements to say either demolish the building or modify it so that there is compliance with the terms and conditions of the extant planning permission. A choice of requirements in those situations is fine, but the requirement on its own to demolish the building is not excessive if the development was constructed without planning permission because of the deviation from the approved plans. So the second type of notice, if the notice suggests that the use or building is modified, then we are looking at a notice that aims to remedy the injury to amenity, an under enforcement situation. And I think using the example that I gave earlier, so you might say on ground F here, we've had a notice that alleges the construction of an extension, but the reasons for the notice were that the extension causes overlooking. And so the notice, you know, the LPA, they didn't mind the extension except for the overlooking. So the only requirement is that a particular window is bricked up. Then we do have an under enforcement situation, and it might be possible on ground F to say, well, actually, if your only aim is to remedy the loss of privacy next door, then we could put in obscure glazing instead of bricking up the window. That is an argument that could be entertained, but with a note of caution that even when the notice is concerned with injury to amenity, an inspector cannot consider planning merits under ground F. Planning merits can only be considered via ground A if that is pleaded and accepted and the fee is paid. And another constraint to variation is that a notice cannot require the carrying out of the scheme. Notices must tell the recipient what they have done wrong and must do to put it right. If the requirement is to submit a scheme to the council, then for approval, then the recipient doesn't know what they've got to do to put the allegation right. So the requirements, if we're going to vary them, they still must be clear, as well as not excessive. And then finally, ground G, which is that time for compliance falls short of what is reasonable. The word reasonable here shows that the inspector has discretion. However, planning merits are not considered under ground G. By the time we get here, ground A has either not been pleaded or has failed. All opportunities to obtain planning permission, quash the notice, modify the allegation or requirements have gone. The question of what period for compliance with the requirements is reasonable must be considered on balance between the harm caused by the development and the interests of the appellants and any other occupier in respect of compliance with the requirements. And so just to stress, by the time we're at ground G, it is uncontested that there is harm caused by the development because ground A has either not been pleaded or it has failed. So there is uncontested harm or no longer contested harm, but you're balancing that versus the interests of the people who are affected by the requirements. And I think generally for inspectors, we do have discretion here. Where the alleged development causes immediate or grave harm, perhaps in relation to highway safety, that would generally weigh against extending the period for compliance. Where upholding the notice means making people homeless, that might weigh in favour of extending the period. And ground G is the only ground in addition to A where human rights considerations can be engaged. But it is a judgment call based on the evidence. An inspector may decide that a reasonable period for compliance with the requirements falls somewhere between what the notice said and what the appellant wants. We aren't bound to agree with either one suggested period or the other. There is no limit either to what a reasonable period for compliance may be, but inspectors do generally resist giving more than 1 year unless there are exceptional circumstances, because then we are in the territory of temporary planning permission, and the route to gaining that is again ground G. So that's about the end for me. I will just say finally in relation to grounds F and G is that I mentioned earlier an inspector can vary the terms of the notice so long as doing so would cause no injustice. If there is no appeal on ground F or G, an inspector will still deal with anything obviously awry with the requirements or the period for compliance. For example, we would delete a requirement to resume the lawful use, which is obviously excessive. But I would say to recipients and appellants, don't rely on us exercising that power if you have a particular case to make for varying the requirements or period. Grounds F and G are your friends there. And on the subject of friends, I shall hand you over to my esteemed colleague, John Murray. Thank you for listening.
Thank you very much, Jeanie. And you look so smart, I decided to put a jacket on after all. So as you can see, I'm going to talk about the planning unit, primary incidental uses and mixed uses. And as that first detail slide shows, I'm going to break this down into 4 areas. Why is the identification of the planning unit important? What to consider when identifying the planning unit, primary, incidental and mixed uses, and the particular implications of all of this for enforcement. I'm going to focus mostly on the planning unit, but touch on primary and incidental uses as those topics are interrelated. Now, this isn't a subject which lends itself easily to comedy, so I'm afraid my presentation will not be packed with hilarious anecdotes, but I do remember appearing for my local planning authority at a public inquiry more than 30 years ago, during which there was quite an extensive and lengthy debate about the planning unit. But in closing submissions, the appellant's advocate said the discussion about the planning unit was interesting. And then he just moved on to something else. And I was tempted to follow the same approach today, but I've been given about half an hour to talk about this. So that's about as funny as this is going to get. So take another gulp of black coffee and I'll have to let you be the judges of how interesting this all really is. So if we take a look at the first detailed slide, why is the identification of the planning unit important? Well, the expression planning unit doesn't appear in the Town and Country Planning Act or the General Permitted Development Order. And as the Encyclopedia of Planning Law and Practice says, the planning unit is a concept which has evolved as a means of determining the most appropriate physical area against which to assess the materiality of change, to ensure consistency in applying the formula of material change of use. And of course, for there to be a material change of use, there must be some significant difference in the character of the activities from what has gone on previously as a matter of fact and degree. And significance can change dramatically depending on the physical area you choose to look at. The bigger the area, the less likely it is that a change in the use of part of it will constitute a material change in the whole. And we'll look at some examples later. And now we can look at the next slide to tell us what to consider when identifying the planning unit. And of course, the leading case is Birdle and Williams versus Secretary of State and New Forest District Council from 1972. Now, this was a divisional court ruling, so the Lord Chief Justice, Lord Widgery, was on the bench, but Mr. Justice Bridge gave the leading judgment. And he said that the starting point is the unit of occupation. And to quote him directly, he said, it may be a useful working rule to assume that the unit of occupation is the appropriate planning unit, unless and until some smaller unit can be recognised as the site of activities which amount in substance to a separate use, both physically and functionally. Now, the unit of occupation may coincide, but is not defined by ownership or tenancy. If the area is occupied for one or more primary uses, it is the area which is occupied for one or more primary uses, and we'll come back to that. Moving on to the practical application, everyone tends to remember physical and functional separation, but don't forget the starting point, and don't just assume that the area of freehold or long leasehold ownership, or even the area covered by a planning permission, is necessarily the unit of occupation for our purposes. And a classic illustration of this and the significance of the planning unit is provided by the Church Commissioners versus Secretary of State case from 1996. A single shop, Unit B12, in a shopping centre comprising over 300 units, that was occupied by an individual trader was held to be a separate planning unit with its own primary use, even though it was located within a shopping mall, and it could be said that the whole centre was occupied for retail purposes by the landowners. Now, I do like quoting judges directly, but this was an oral judgment given off the cuff, as it were. And whilst I couldn't possibly say this, if you read it, you might think that the bit containing the essential reasoning is not a model of elegant concision. However, essentially, it boils down to this. If a discrete unit is under the control of an individual, that will be the unit of occupation. A change of use of one shop might not be sufficient to materially change the character of the use of the centre as a whole, which in that case included shops and restaurants. However, it was much more likely to be material in relation to the individual shop. In that case, the Secretary of State found that the change of use of Unit B12 from a shop to a restaurant involved a material change of use, and the court was happy with that. Looking at another illustration of this in practice, the next slide covers Johnston and Johnston versus Secretary of State from 1974, where individual garages or blocks of garages within an overall complex of 44 units were treated as separate planning units on the basis of the occupancies. In this case, the Lord Chief Justice, Lord Widgery, who I mentioned a moment ago, said, on the face of things, the planning unit is the area occupied as a single holding by a single occupier. He did add, I would not for a moment wish to suggest that that is an absolute rule admitting of no exceptions, but that it may be the first step in the approach to this problem, I think is clearly right. And it is not without interest that Mr. Haynes, leading counsel for the appellant, has not been able to show us any reported case in which the planning unit has been settled as being an area of land comprised in two different holdings or occupations. And in that case, Lord Justice Widgery also said, I would have thought that in almost every case of a block of flats, the flats being let to separate and different tenants, the planning unit would be the flat in question. And I find it difficult to imagine that that wouldn't be the case. I'd also suggest this is also likely to apply, for example, to different units on an employment park, though as was said in Johnston, this is always a matter of fact and degree. The consistency referred to in the Encyclopedia of Planning Law and Practice is an ideal to strive for, but it may not be easy to achieve. Excuse me. Now, you might think I've dwelt too long on the unit of occupation, but I've often seen people start with a large area, clearly occupied by several different people or entities, and then just dive straight into the issues of physical and functional separation. So turning to physical separation, as the next slide illustrates, sometimes physical separation will be very clear, as there will be walls, fences, hedgerows, or other substantial physical barriers, but it could be more subtle. I find the expression used by Bridge J in Birdle very useful. He talked about a recognisably separate area. It remains a question of fact and degree in any case, but different surface treatment, for example, might give rise to a recognisably separate area and therefore sufficient physical separation. Moving on, the following slide provides another real-life example. I had an enforcement appeal concerning permanent residential occupation of a boat on a canal. The whole of the 14.5-mile long Driffield navigation was a single waterway created by man-made improvements under Acts of Parliament at the end of the 18th century. The whole canal was managed by the Driffield Navigation Trust and could be regarded as a single unit of occupation. And the appellant argued that the whole canal was the planning unit, which would have made it extremely unlikely that their use resulted in a material change. However, the area identified in the enforcement notice and extending to approximately 0.6 kilometres in length could be readily identified as a physically distinct section of the canal. In that section, the stationing of boats in significant numbers was possible through the provision of mooring facilities. As a matter of fact and degree, I found that area to be the planning unit against which the materiality of any change of use could be assessed. But it was still a large area, and the great majority of moorings were used in the course of navigation or as home moorings for the storage of boats, rather than residential occupation. So I still found no material change of use. By the way, if you suspect that that image is not a picture of the Driffield navigation, you are correct. It is, of course, a little further to the south in Hull. In the next slide, we start to look at functional separation. A physically recognisably separate area will not form a separate planning unit unless it is also occupied for different and unrelated purposes. Consider the example of the unit of occupation comprising a dwelling house with a garden and garage. If the householder starts carrying out car repairs on a significant scale in the garage, the whole unit of occupation will be a single planning unit in mixed use as a dwelling house and for car repairs. This is because the functional relationship remains, although there might be a degree of physical separation between the uses. However, if the householder lets the garage to a different operator for car repairs, the dwelling house and garage will constitute different planning units. Garage will be a separate unit of occupation, and its use will be physically and functionally separated from that of the house. The following slide takes us to another example from a real case. One of my own cases required consideration of the unit of occupation, physical and functional separation. It concerned an enforcement notice, in short, alleging the material change of use from one lawful mixed use to another, more complex, unlawful mixed use. The site is shown in diagrammatic form on the following slide, which I hope you can see. But the overall site identified on the notice plan was owned by the appellant, A, but he let parts of it to others. Now, within the overall site, part of the U-shaped building complex, which actually looks like a C-shaped building on that plan, but that was used as an office. It was recognisably separate. It was a separate unit of accommodation and was separately occupied by B under a written tenancy agreement. So all those letters on the plan, A, B, C, D, refer to different occupiers. A storage compound was also a recognisably separate unit occupied by C for the purposes of their business and subject to the payment of rent. Another part of the U-shaped building complex, a dwelling in the old stables and its adjoining fenced garden, also constituted a recognisably separate unit occupied by D, subject to the payment of rent. Another part of the U-shaped building complex was occupied by A, the appellant, but it was also a recognisably separate area and used by him for commercial storage in connection with his off-site catering business. The remainder of the site was used as woodland and for the stationing of 3 mobile homes for residential purposes. This area was occupied by A, the appellant, but other individuals also lived in 2 of the mobile homes. The mobile homes could be stationed anywhere in this area rather than in individually separate or physically distinct areas. The parking manoeuvring area was in the appellant's overall control, but its use was shared by everyone on the site. It was functionally separate from the rest of the site and physically recognisably separate due to its hard surface contrasting with the surrounding grassed areas of the remainder of the site. So in that case, I found that there were in fact 6 planning units, one of which was in mixed use as woodland and for the station of caravans for residential purposes. The next slide brings us back to the judgment in Birdall, where Bridge J suggested there were 3 broad categories of distinction. The first being a single planning unit, where the unit of occupation has one primary use and any other activities are incidental or ancillary. The second is a single planning unit that is in mixed use because the land is put to 2 or more activities and it's not possible to say that one is incidental to another. And finally, the unit of occupation comprises 2 or more physically separate areas which are occupied for different and unrelated purposes. Each area that has a different primary use ought to be considered as a separate planning unit. So it's important to understand what is meant by primary and incidental, and the next slide takes us to that. Put simply, a primary use is a main use, and incidental uses would be subsidiary activities which are functionally related to the primary use. Incidental uses may fluctuate without there necessarily being a material change of use of the planning unit. For example, there may be various subsidiary activities at a factory, such as canteens, offices and staff and visitor car parks. Those activities will usually be incidental and the primary use will be as a factory. Moving on to the next slide. Mixed uses. Well, this is where 2 or more primary or main uses exist within the same planning unit. And staying with the factory scenario, if, for example, the office element expands to serve the business's factories worldwide, that may become a primary use, such that a mixed use as a factory and offices arises. It's important to note that activities carried on within a single planning unit cannot be incidental to activities carried on outside that unit. And that's the Essex Water Company versus Secretary of State case from 1989. And the following slide takes us back to the example of the domestic garage. The parking of and occasional repairs to the family car will be incidental to the dwelling house use of the planning unit. If the occupier starts carrying out car repairs on a significant scale, that will become a primary use, and the planning unit will be in mixed use as a dwelling house and for car repairs. It's important to remember that a mixed use is a single use in planning terms, and the allegation in an enforcement notice should refer to all components of any mixed use, even if only some elements are required to cease. And the reference there is East Sussex County Council versus Secretary of State from 2009. In a complicated mixed use site, if the allegation refers to primary and incidental uses, it should make clear which is which. Now, the next slide touches on other consequences of a mixed use being a single use, and they include that you cannot succeed on a Ground D enforcement appeal or a Section 191 lawful development certificate application or appeal if only some elements of the mixed use have been carried on for the requisite period. The single use won't have carried on for the requisite period. And whilst materiality must always be considered, the intensification of one element of a dual or mixed use to the exclusion of the other may amount to a material change of use of the unit as a whole. The following slide takes us to the implications for enforcement, and I've put that heading, no need to direct an enforcement notice at the planning unit, with a question mark at the end, enigmatically, but that I'll explain that, I hope. It's not open to a local planning authority to divide up the planning unit artificially so as to achieve a more restrictive effect than would result from a notice directed at the unit as a whole, i.e. by making it more likely that a change is material assessed against a small area. However, strictly speaking, an enforcement notice does not have to be directed at the whole planning unit, nor indeed does it need to identify it, and that's Hawkey and others versus Secretary of State and Richmond upon Thames versus Secretary of State from 1971 and 1987 respectively. In Richmond, the deputy judge said, "The question as to what or what is not a planning unit is not critical at the stage of the allegation by the authority contained in the enforcement notice, but it becomes critical at the time when it has to be established as to whether or not there is a material change of the planning unit on the fact of the particular case. But he added, quote, "Of course, any prudent authority would ask itself that question before it issued and served an enforcement notice," unquote. I'm sure we've got many representatives of prudent local planning authorities here. But it seems to me that you would need a good reason for not seeking to direct a material change of use notice at the relevant entire planning unit, and you may get into difficulties if you have not properly addressed that issue, hence the question mark in the heading. So this next slide expands on that as it covers the correction of the notice to reflect the planning unit with yet another question mark. So it may be possible to correct a notice to refer to the right planning unit, but increasing the area of land to which the notice relates is likely to cause injustice. I don't think that conflicts with anything Jeanie told you earlier. Furthermore, where one larger area covered by the notice really comprises several smaller planning units, correcting the notice to reflect that may require a very extensive rewriting of the notice, including its requirements and the periods for compliance. And it may be that such substantial alterations cannot be done without causing injustice, given the implications for how the parties submitted their cases. Indeed, that was my conclusion in the appeal I referred to earlier with the U-shaped building. And at least one other I can recall where the necessary corrections would have resulted in a notice very different from the one served in the appellant. So can we go to the next slide, please, where I talk about the further significance of the planning unit. So the creation of a new planning unit, a use which is authorised by planning permission or which became lawful through the passage of time is capable of being extinguished by the creation of a new planning unit in respect of the land in question. And that's Stone and Stone from 2014. And the following slide explores that further, considering the implications for section 57, subsection 54 of the 1990 Act. In the context of the recent much publicised case, Titchfield Festival Theatre Limited versus Secretary of State from 2025, and the relevant facts in Titchfield were as follows. There is a large building on the site comprising 3 distinct areas, A, B and C. The enforcement notice was directed at areas B and C, and the appellant sought to rely on a lawful use right for areas A and B as a theatre, such that the notice should not require the cessation of the use of area B as a theatre. Now, section 57.4 says, where an enforcement notice has been issued in respect of any development of land, planning permission is not required for its use for the purpose for which, in accordance with the provisions of this part of this Act, it could lawfully have been used if that development had not been carried out. And the next slide sets out what the court found. Well, the service of an enforcement notice may allow a landowner to revert to previous lawful use. However, Titchfield confirmed, following Stone and Stone, that an existing lawful use is capable of being extinguished by the creation of a new planning unit in respect of the land in question. And the judge said, it is clear that the exception created by section 57.4 relates to the land which is the subject of the enforcement notice. So if the lawful use rights relate to a different planning unit, section 57.4 won't preserve them. And he said, the judge said at paragraph 79, the inspector was right to say that land which is subject to the enforcement notice was areas B and C, and that the lawful use relied upon relates to areas A and B. The inspector was right to say that the land subject to the enforcement notice did not have a lawful use, as the lawful use does not include area C. And given her findings on the creation of a new planning unit, the inspector was right to say that areas A and B no longer exist as a planning unit. Now, you might think I only quote those passages in detail because they keep repeating the phrase, the inspector was right. That is a phrase we like to hear, and I respectfully commend it to all judges, in fact. Our penultimate slide is just an aside in relation to section 57.4. That provides a right to revert to use which is lawful in accordance with part 3. Taken in isolation, this might suggest you don't have the right to revert to a use which has become lawful through the passage of time, rather than through a grant of planning permission under part 3. However, whilst it's in part 7 of the Act, section 191 defines lawful, quote, for the purposes of this Act, unquote. So that must include part 3. Furthermore, Titchfield concerned lawful use rights acquired through the passage of time, and there was no suggestion that this alone deprived the appellant of the right to revert under section 57.4. So that takes us to the final slide, which has nothing on it save for an indication that it's now your opportunity to ask questions, but I hope you found that useful. Thank you.
Thank you, Jeanie and John. I'm sure that was found very useful. Yes, lots of applause there. Look, going up the screen. So thank you very much. We've got a little bit of time left before we need to finish. I think we've probably got to most of the questions that have been asked, and Jeanie and John can perhaps keep having a quick look at them. But just to pick out a couple of interesting ones, let's see if we can pick out some of those. Jeanie, there was a question that you might have seen, and I think you've responded to as well, in relation to when a notice alleges a material change of use, whether it needs to set out what the former use was. And I don't know if you want to respond to that.
Well, yeah, it has been covered, but for people who haven't seen it, I think you answered it really, Claire. You know, it isn't essential to say what a material change of use was from. It's only essential to say what a material change of use was to. However, it is, as Claire said, useful to set out what the material change of use was from, in case there is a question as to whether the change of use was indeed material. So, but whether the notice says what the change of use was from or not, you can still have to answer that question. So, so it isn't essential to say it, but it can be helpful. I think the other thing I added in the chat is that a greater difficulty for us, and I guess really for everyone, is where the land is in a mixed use and the notice doesn't tell you all the elements of the mixed use which are going on. Perhaps it omits to mention something that is lawful, or it's just not been described correctly, and that can cause, if you like, more difficulties for us, I think, is when the uses that have the change of use to is not described correctly. So it can be difficult sometimes to identify all of the uses where it's a mixed use. But no, the simple answer to the question is it's not essential, but it is helpful to say what the change of use is from.
Okay, thank you. John, there's one, I can't actually see it in the chat now, but I think I can find it. It was relating to planning units. And the question is, what if there is no demarcation, but the land considered to be within the planning unit is so minimal that the local planning authority decided not to include it in the notice as it was in a different ownership, i.e. under enforcing the additional width of hard standing. Yeah, so just how would you go about that if there's no demarcation, but the land considered to be within the planning unit is so minimal that the local planning authority decided not to include it in the notice as it was in a different ownership? Don't know if you've got any thoughts on that at all.
Well, my first thought is I'm not sure my brain is big enough to actually comprehend the question. But I mean, the first thing that comes to mind is that under enforcing the additional width of hard standing, well, obviously that the planning unit is a concept which is relevant to material change of use rather than operational development. That said, I appreciate that a material change of use notice might require the removal of hard standing, which has been put down to facilitate a material change of use. But I don't know whether the questioner was coming from misapprehension that planning unit was relevant to offer an operational development notice. I'm just trying to grapple with the concept of an area of that land being so minimal and yet part of the planning unit. I think it's just a question of identifying what the planning unit is. If in fact it is, if in fact there has been an area of land missed out and it's part of the planning unit, this might be a situation in which you could correct the notice, because if this area is so minimal, the implications there may not be injustice. I'm struggling a bit and I'm waffling a bit, but I think the main point is that, as I said, planning unit is only relevant to a material change of use and not to operational development. I hope I'm not too wide of the mark there with what the question was looking for.
Thank you, John. Thank you. And just picking up on perhaps some of the ones that have been upvoted the most, they have been answered in the chat. But there's a question about putting land back to its previous condition and how much detail should a requirement say is required. So what, in terms of the required works to restore the land to its previous condition, and both myself and Jeanie have answered that now. And just to set out for those of you that haven't had a chance to look down the chat yet, to say to restore the land to its original condition is often sufficient, and the landowner is actually best placed to know what the previous condition was. So that's often fine just to specify that. Let's just have another look down.
At the same time, though, Claire, I would say that a notice can be very specific and it isn't necessarily excessive. I mean, and I think that's pretty certainly the case in listed building enforcement, which I realise is a whole topic on its own. I did want to have a notice where the requirements to cease the residential use also went as far as removing the spice jars from the kitchen. So, I seem to remember that bit was excessive because the lawful use could include a kitchen, but it wasn't. But other other scrutinised, other minute details of it were not excessive. So, but simply, if in doubt, you can stick to restore the land, and that's fine.
Yes, yes. Perhaps if I can just add, yes, that is perfectly fine. I think if the local authority can put more detail in, then obviously that's helpful, particularly to the appellant, in knowing what it is that they've actually, or to the recipient, in knowing what it is they've actually got to do. But you've got to be confident that that is what the condition of the land was. I mean, I've had cases where there's been timber windows replaced with new PVC, and then I've had a notice which 3 pages of specification for the replacement window because the conservation officer has been consulted, and this is what they would want, but there's no evidence that that's what anything like really in detail what was there before. I mean, sometimes a photograph is useful. You can attach a photograph to it if you've got a photograph of land prior to the breach, which illustrates the condition, and that can be useful. So be careful in not overstating what's required to return the land to its condition.
Yeah, thank you. We've got a question that relates to a material change of use notice, or potentially a material change of use and an operational notice. So the question is, what are the benefits of issuing 2 types of notices on a piece of land? One for operational development and the other a change of use, or would you stipulate the buildings on the land to be removed as part of the change of use notice, and only issue 1 notice? I don't know, John or Jeanie, if you'd like to offer some thoughts on that.
I think
Yeah,
I think it very much depends on the detail and the circumstances. I mean, you would, if it depends on how much they are linked, and they ultimately could go into the same notice, but then they don't have to if they are separate breaches of planning control. I think I would be loath to sort of give a hard and fast rule there, to be honest. So I think it just very much depends on the circumstances. John I'm sure will usefully add, though.
No, the only thing I was going to add was the part of the question was whether you should perhaps require the removal of the buildings as effectively facilitating the material change of use. Well, that depends. If the buildings themselves are clearly operational development in their own right, which should have been the subject for their individual of the notice. You can't rely on the Murphy principle to treat it as operational development which facilitates the change. If it's something which is effectively causative of the breach, for example, if you've got a new dwelling that's been constructed, if you issued an enforcement notice alleging a change of use of the land to residential and required the removal of the building as facilitating that, that would be the wrong thing to do. You should have taken enforcement action against the construction of the dwelling.
Okay, thank you, Jeanie and John. I'm going to bring it to a close now. We've just passed the 2 o'clock mark, so thank you so much for attending. I hope you found it useful. I'd like to thank Jeanie and John for taking the time to do this today, and those people that are behind the scenes as well that you can't see, that have been busy helping us with updating the questions and keeping everything running smoothly. So thank you. We would, of course, appreciate your feedback, so do complete the feedback form. I noticed that the link to that is now in the chat, so we'd really appreciate that. Thank you, and look out for our advertising of the next webinar that's coming up in September in relation to local plans. You can subscribe to alerts, and then we can let you know what webinars are coming up and when. So thank you very much. Thank you.
Thank you.
Thanks, everybody. Bye.